We are going to start with State of Ohio versus Juan Torres. It's case number 18CA011451. Both parties are present, so each of you will have 15 minutes to present your arguments. The appellant, of course, may reserve up to 5 minutes for rebuttal. Let me know, because I'll keep track of the time, and I'll say something as you get close to your rebuttal time. If there are victims or children involved in our cases, we ask that you use initials. We use the front podium. It is videotaped and played on our YouTube channel, so we ask that you stay close to the podium and keep your voice up. We've read the briefs, so we're ready to proceed if you are.
Thank you, Your Honors. May it please the Court, Lorain App.No on behalf of Mr. Torres. Your Honors, we're here today on an issue of first impression for any court in the state of Ohio. As far as I know, nobody's challenged the forfeiture statute, the OVI forfeiture statute, on equal protection grounds before. So this court will be breaking some new ground if it were to agree with my argument. But I just want to preface some of my arguments with a couple things. Number one, I'm not here to advocate that the court reduce the punishment for third-time OVI offenders. Obviously, if you have a third OVI within 10 years, you have a problem, you haven't learned your lesson, you should be punished severely, and I agree with that. And forfeiture might be a means to affect that punishment. But what I'm here to do is advocate that everyone who has a third and 10 OVI be punished the same, and severely, for that matter. So, just to add some context of where I'm coming from, I'd like the court to know that. Now, the overriding principle for any equal protection challenge is that all people who have committed the same offense need to be treated equally. In this particular case, we have a class of offenders who committed a third OVI within 10 years, and they happen to own their vehicles. They're subject to forfeiture, and they're also subject to a 5-year registration ban. That is a very severe punishment. As the court is well aware, vehicles are valued in the thousands of dollars, if not tens of thousands of dollars. And just for a little context, the maximum fine under a third-time OVI is $2,750, I believe. So almost any vehicle that is going to be forfeited is going to exceed the maximum fine. So that's a very severe punishment. In this particular case, my client, Mr. Torres, had a pickup truck that was paid off, paid in full, and the trial court valued his vehicle at $15,000. So not only did he get the fine, he's also getting this $15,000 punishment. Now, we would compare that to the other class of people who do not happen to own their vehicles. Those people completely escape the forfeiture penalty, and they completely escape the 5-year registration ban. And right there is where the constitutional violation occurs, because we are treating those two people who committed the exact same offense. And all intents and purposes are equal, except for they don't own their vehicle.
Well, counsel, delving into that one issue more closely, if I have a leased vehicle and the car is registered in my name, even though it's titled to the leasing company, the bank, whatever, isn't it subject to the mandatory forfeiture proceedings because it's registered in my name?
It may be subject to the forfeiture proceeding, but it is not going to be forfeited if the owner of the vehicle, which would be the leasing company, comes forward, enters an appearance with the court, and says to the court, this vehicle belongs to us. It would be unconstitutional for the court to forfeit that vehicle under State versus Hochhausler, that's 76 Ohio State 3rd 455, which says that a third-party owned vehicle cannot be forfeited in a DUI case. It's a denial of due process, basically.
Okay, here's the part I'm struggling with on that. So if I have a leased vehicle, I have an ownership interest, don't I? Because as long as I make my payments, at some point at lease end, there's going to be a residual value. So could the court not just order it forfeited as it relates to me, and then my penalty would be whatever that lease term would be?
Well, you have a rental interest in the vehicle. When you're leasing, you're basically renting the car from the leasing company who owns the car. And at the end of the lease, you either turn it in or you would buy it out. One of those two situations, so that I don't think the court could order that car to be forfeited because it doesn't belong to the offender. It's the exact same thing as if you were renting the car from Enterprise Rental Car at the time you committed your DUI. I don't think anyone would argue that the law provides that that car could be taken from the person. And that particular situation, there's other contexts where this would apply. If you're driving your mother's vehicle, for example, or if you own a corporation and your corporation owns the vehicle that you're driving, they're not registered to you, they're not subject to forfeiture. So there's a lot of different situations where you're going to escape the forfeiture penalty opposed to somebody who happens to own their vehicle. So that creates a huge problem there because that's a disparate punishment.
One more question,
Sure, fire away.
probably more than one, but, so, the statute that you are saying is unconstitutional on equal protection grounds is a statute that says these are the mandatory, it says a lot of things, but it says these are mandatory, what the court shall do when a person in this position is convicted of this offense.
Yes.
But it also says that if it's subject, it's forfeited, and then you have to look at the criminal forfeiture statute, which lays out what happens if other people have an interest in them. So does that forfeiture statute not clear up the equal protection argument that you have? I mean, does it not stop things from happening that your argument says always happen by virtue of this mandatory statute?
No, I don't think so. I think you're talking about 451119. I cited my brief, but yeah, I know what statute you're talking about. But in that statute, there are certain circumstances where the court allows third parties to come in and assert their interest. And it's kind of a segue into one of my arguments for what the remedy is for this constitutional violation. So in the statute you're talking about, if somebody comes in, I'll propose this hypothetical. You own your vehicle, it's titled to you, you have a lien on it, you took a bank loan out on the car. So the bank would come into court and say, Your Honors, that's our collateral, we're entitled to that vehicle, don't forfeit it. And the court would not be able to forfeit it. But what the court could do is, in that circumstance, they could fine the defendant in the amount of the reasonable value of that vehicle in that circumstance. But that doesn't apply if you're renting, that doesn't apply if you're driving somebody else's vehicle. And what I'm arguing here today, and it's at the very end of my brief, is that particular provision where you define the value of your vehicle, that should apply to everyone. So that if you commit a third and 10 DUI, if you own your vehicle, it's getting forfeited. So you got the punishment. If you don't own your vehicle, you're getting a fine in the amount of the value of whatever vehicle you were driving, regardless of ownership. That would level the playing field for everybody. No one would escape it then. All the other punishments under the DUI statute, there's mandatory minimums. Mandatory jail, mandatory fine, mandatory license suspension. No one can escape those. You're going to jail no matter what. You're going to pay a fine no matter what. You're going to get a license suspension no matter what, except for the forfeiture. That's the only mandatory minimum penalty that some people are escaping while others are not. So I think the question, what it all boils down to, if we're getting into the rational review analysis, is how does allowing a certain class of people to escape the forfeiture, how does that advance the state's legitimate interest? I'm pretty sure that the state is going to come up here and say that the legitimate interest is to prevent recidivism. We want to take away people's cars, to teach them a lesson so that they don't go out and commit a 4th, 5th, 6th DUI. But applying the key question to our situation here, how does allowing a class of people to escape this punishment, how is that advancing the state's interest in preventing recidivism? It doesn't. They're not being punished in this respect. So if you're not punishing somebody, you're not teaching them a lesson, you are not preventing recidivism by allowing an entire class of people to get off the hook for this very punitive punishment. So I think it fails rational review in that respect. I do want to reserve 5 minutes for rebuttal. I apologize.
You have about 57 seconds before you're at the 5-minute mark.
Okay. Well, I'll reserve the rest of my time, Your Honors, if you don't have any further questions.
Questions, Judge? All right, then we will have 5 minutes for rebuttal.
Thank you.
Counsel, obviously you'll have 15 minutes.
Good morning, Your Honors. May it please the court, my name is Farah Ameka and I represent the state of Ohio. In this case, it involves an issue that was determined by this court and by another court of appeals, that whether the different treatment of OVI offenders based on the ownership of their vehicles violates the Equal Protection Clause has already been determined. It does not. Now, as counsel indicated in their opening argument, the specific provision for the forfeiture statute out of OVI has not been addressed by the courts, but analogous situations under other provisions in the OVI statutes have been reviewed by the courts. And in this court, particularly in Akron v. Kirby, it was determined that the distinction between ownership and leased vehicles, or non-leased and leased vehicles, was not one that violated the Equal Protection Clause. That happened in the mid-90s. There were other cases, State v. Sanders, and then another trial court case, Baker, in the mid-90s that discussed these issues, determined that they did not violate the Constitution, and there has not been a successful challenge since that time. So the state submits to the court that this issue has already been resolved, it's been brought before this court, and it's determined that the statute passes constitutional muster. The reason for this is, first of all, the defendant has a very difficult burden to overcome. The defendant has to prove beyond a reasonable doubt that the provision in the statute is unconstitutional. As presented in the appellant's brief here, they're arguing that the forfeiture statute on its face and as applied in this particular case violates the Equal Protection Clause. They have to prove that beyond a reasonable doubt. That is a difficult hurdle to get over, particularly where you have a strong presumption in the state of this, in favor of the state, where you have a statute that addresses public health, safety, and public welfare. That is what the OVI statute does. So here you have a defendant who's asserting this argument and is not able to surmount or overcome that hurdle. When you're looking at the constitutionality of this type of a statute, any doubts as to constitutionality must be construed in favor of the state, and great deference is paid to the state's interest in enacting that legislation. First, the state would argue that the Equal Protection Clause is not even invoked in this particular instance. The Equal Protection Clause applies to similarly situated people who are treated differently under a legislative enactment. That is not the case here. You have OVI offenders who have a certain number of convictions, who have different status as it relates to the ownership of their vehicles. Particularly, you are talking about the classification of property, the classification of a vehicle. You're not necessarily even talking about a classification that relates to persons. So whether or not the Equal Protection Clause is even a question here is the first step in the analysis.
Counsel, if I can stop you there as to whether or not it relates to persons. So if I'm driving a motor vehicle and let's just say it's someone else's, it's not mine, but it's registered in my name, and I am subject to one of these mandatory forfeiture penalties. How do I have an Eighth Amendment argument? Because since these cases that you've cited, we now have this whole Eighth Amendment forfeiture argument from the Supreme Court. How do I make my Eighth Amendment argument that this is an unreasonable fine if I didn't have an ownership interest in the vehicle? But because it's registered to me, it's subject to, it must be mandatorily forfeited. Or subject to the enactment of criminal forfeiture statute proceedings.
Well, before I answer the question, the excessive fine and Eighth Amendment argument was not made in this case.
Right, I understand that.
And so then how you make that argument as to whether or not it's an excessive fine, it's difficult to do that.
Well, because we're arguing equal protection.
Right.
And we're just saying, this person has these defenses or rights in a proceeding, but this person doesn't. So what if I have an Eighth Amendment argument, but I don't in another case? Just flip it.
Well, I mean, the Equal Protection Clause relates to the enactment of that particular legislation and how it affects similarly situated people. The fact that the Eighth Amendment argument is no longer on the table is, I would argue it's not relevant in this particular case. The issue as to whether or not the Eighth Amendment applies turns on, as you said, whether or not the person owns the vehicle. They're not going to have that excessive fine if they do not own the vehicle.
Thank you. You've answered it. Thank you.
Okay, thanks. Yeah, I'm prepared for the equal protection argument. And so with that, equal protection doesn't even necessarily apply in this case because, as I said, there's a classification based on property, whether or not the vehicles are registered in the offender's name. And then, so you're not dealing with a classification based on people. And then where you have offenders who have the vehicle registered in their name, they are all treated similarly under the statute. Where you have offenders where the vehicle is not registered in their name, they are all treated similarly under the statute. So what you have is differently situated persons being treated differently. That does not invoke the Equal Protection Clause. However, if the court were to find that because you are dealing with OVI offenders with a certain number of convictions and those are persons who are similarly situated, the state would argue that the provision passes the rational basis test. And as counsel alluded to in their argument, the distinction is rationally related to the government's interest. There are many cases, and several of which that we cited in both of our briefs, where I find that the state has a legitimate interest in keeping drunk drivers off of the roadways. That is the purpose in the forfeiture statute. For those offenders who have the vehicle registered in their name, they forfeit that vehicle so that they have another hurdle or not as easily able to get back on the road and reoffend. It is not a perfect solution to that issue. However, equal protection does not require that under an equal protection analysis. It doesn't have to be the very best approach to meeting the government's legitimate interest. It is related to it in that if that person no longer has that vehicle, it'll be harder for them to reoffend. The fact of the matter is, whether the vehicle is forfeited or not, anybody can go out and get in somebody else's car and drive. There are lots of other sanctions and remedies in the OVI statute to address that, with license suspension and registration and so on and so forth. With that, the state would argue that the rational basis test applies because you do not have a suspect classification involved, and you also do not have a fundamental interest involved. That's why we're talking about the rational basis test. It is the least level of constitutional scrutiny. It is easily met in this particular case, and as I argued previously, it is an issue as it relates to the ownership status of an OVI offender that has already been resolved by these courts more than 20 years ago. Now, in the cases that we presented in our briefs, those cases do not specifically discuss the forfeiture statute, but they do discuss the seizure of the vehicle prior to conviction, as well as impoundment of the vehicle prior to conviction. And there is a difference in how those offenders are treated based on whether or not they own their vehicles, or they lease their vehicles, or they're renting their vehicles. Counsel, in his argument, argued that a leased vehicle is similar to if you were to rent to enterprise. That is not an analogous situation. You do not have a vehicle that is actually registered in the name of the OVI offender in that case. You have a vehicle that they are renting for a period of time. They have temporary paperwork in order to allow them to have access to that vehicle. So it is not an analogous situation. in Akron v. Kirby, the court found that though a provision in the OVI statute may place a greater burden on one class of Ohioans as opposed to another, the Equal Protection Clause is not violated. It is important to note that this case involves OVI offenders who are differently situated. Whether the vehicle is registered in your name or not is the classification upon which that difference is based, and it does pass equal protection muster. It does not violate the Constitution, and so the state would ask that the court uphold the trial court's criminal forfeiture order for the defendant's vehicle and also affirm the decision of the trial court. Thank you.
For those people who own a vehicle or have it registered in their name, who are subject to forfeiture, are they all treated equally when one of those or a group of those people may live in an urban area where they get public transportation, whereas others may live out in the country where public transportation isn't as readily available, or
Well,
you know, one may forfeit a car that's worth $20,000, where another would, you know, maybe has a car that's small. Isn't that unequal treatment within that class?
Well, it's, those are collateral consequences of the classification of the forfeiture statute. The particular argument around the rural versus urban and access to public transportation has already been presented in the cases that the state cited in its brief, and it was found that those are collateral consequences that do not have to be taken into consideration under equal protection. As I stated previously, a provision may have a different impact on Ohioans or place a greater burden on certain Ohioans. That does not necessarily mean that it violates the Equal Protection Clause. As far as the value of the vehicle, I mean, there are Ohioans who have access to certain resources, and there are Ohioans who have access to fewer resources. Those are collateral consequences. Those are not specifically stated within the language of the forfeiture provision that if you happen to make over $50,000 a year, or if you happen to have a home worth, $1 million, then you will have this specific punishment or this specific consequence. Whereas if you are below the poverty line or of modest means, then you will have a different. Those classifications are not found within the actual language. The classification is of property based on whether or not it's registered in the offender's name.
Well, counsel, in most cases, when you're setting a fine, that's up to the trial court's discretion in terms of what all of those considerations would be. How much money you may have just at your disposal could be one of them. In this case, we are talking about a mandatory action. The trial court must forfeit, right?
Yes.
So it's a little different than a collateral consequence, maybe.
Well, there's definitely a classification, and there's a distinction based on that classification. But the statute in and of itself does not dictate the value of what that consequence will be. And the reason behind why there's that distinction is because to try to have a person who does not have a car registered in their name to forfeit a vehicle that belongs to someone else is of no consequence to them at all.
Sure.
Because they are not giving up anything, somebody else is. So the classification has a rational relationship to the government's interest, where you actually have a vehicle to give up in the first place. The value of that vehicle is, again, I would argue it is a collateral consequence. There's no way to know how, whether somebody's driving a hoopty or a Mercedes SUV. Thank you.
Thank you. Counsel, you'll have 5 minutes then for your rebuttal.
Thank you, Your Honors. Your Honors, I know this court is bound by stare decisis, but I just have to point out that, I know there's a burden here that I'm supposed to overcome. And I just would want to point out that there's nothing in the U.S. Constitution or the Ohio Constitution that says that all statutes are presumed constitutional. That is a function of a specific revised code statute that says that. It's not in the Constitution, but I know courts have said that there is this presumption. It's a judge-made thing that I certainly do not agree with. But nevertheless, on to the other issues. This is not a case about analyzing the impact of differential punishments on people. If there is a wealthy man who gets fined $1,000, that's not going to be a big deal, and if a poor man gets fined $1,000, it's going to be a huge deal. This isn't that kind of case. Both people are getting fined. They're both being punished equally. This is a case about somebody who's not being punished versus somebody who's being punished for doing the exact same action. And there's a number of cases, federal cases, state cases that say you cannot perform the same conduct and be punished differentially with the other people. One of the cases I cited that I would ask the court to heavily consider was Cleveland versus Huff. In that case, the court analyzed, it was a solicitation of prostitution statute and a prostitution statute. They both involved the exact same conduct, the exact same elements, but the punishments for those two statutes were different. In that case, the court said that that was a violation of equal protection because you can't do the same action and be punished differentially. So if that principle applies to two different statutes when they're compared, why wouldn't it apply to people within the same statute? Why would you punish two people who committed the same act under the same statute differentially? And I'm glad that Judge Hensel, you pointed out that the forfeiture is mandatory. There is no discretion here. It has to happen. The judges have to forfeit the vehicle if it falls under the statute. That's a really important concept here because there are lots of punishments that are not mandatory, and that if forfeiture were not mandatory, that would perhaps lessen the constitutional violation, or maybe there might not be a constitutional violation at all. But the fact that it's mandatory means that people are definitely going to get their car forfeited, and if you don't own it, you're definitely not going to get it forfeited. I'd also like to point out, the state's attorney made the point that we're dealing with the disposition of property here. This doesn't really affect people or classes of people. The case law says that forfeiture is a fine. It's the exact same thing. There's no difference. So this isn't about property. This is about a fine. Forfeiture is a fine, and there's ample case law that says that forfeiture is a disfavored punishment under the law, and that any forfeiture statute needs to be strictly construed against the state. So that's an important principle for the court to consider when rendering its decision today. Judge Hensel, you also pointed out the Eighth Amendment argument, and I don't know if this panel is going to hear that case, but I have another appeal that makes this same equal protection argument plus the Eighth Amendment argument, and that's going to be heard on December 3rd by this very court. So these cases will probably end up being decided together, but that's in response to a recent United States Supreme Court, Indiana versus Thames, came out, which is where that Eighth Amendment argument is originating from. So based on what we have before us, we ask the court to declare this forfeiture penalty unconstitutional. I think in response, the Ohio legislature will actually increase the penalties for forfeiture in response to this. They're not going to get rid of forfeiture, but they're going to correct the problem, and they're going to fine people who are currently escaping forfeiture, and that's going to raise the punishment to an equal playing field for everyone, and make the community safer as a result. Thank you, Your Honor.
Thank you both for your arguments. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail you each a copy of the court's decision on the day it is released. You could also find the opinions at the Supreme Court of Ohio's website. So very interesting case, good arguments. We appreciate that. Thanks for being here today.